Right, everybody, I think we could go ahead and get started. Just as an FYI, this session is going to be recorded. And as we just wrote in the chat, we are going to be monitoring the chat throughout. So if you have any questions during the presentation, please feel free to write them in the chat. We'll also be doing a question and answer section at the end of the presentation. So my name is Rebecca. I am a third-year law student at BU, and I'll let the other presenters introduce themselves.
I'm Stephanie. I'm also a third-year law student at BU.
And I'm Catherine, also a third-year law student.
And we are all students in the Startup Law Clinic at BU, working with students both at MIT and BU and their startup ventures under the supervision of 3 licensed attorneys. And today we are going to be presenting on the 10 things to consider when forming an LLC. Just as a very brief agenda, we're going to start with a general overview of LLCs, and then we'll get into the real meat of our presentation, which are those 10 considerations, and finally do some question and answer at the end. Before we get started, we just want to give you guys a disclaimer that this presentation is truly a general overview of LLCs. And because creating LLCs are so fact specific, please do not take anything we say today as legal advice to you in your specific circumstances. If you do need specific advice though, and you're a current student at BU or MIT, please follow this link at the bottom of the screen or Google the BU Law Startup Law Clinic and fill out an intake questionnaire, and we would love the opportunity to work with you.
Okay, so there are many entity types that you can choose from corporations, partnerships, trusts. But today we're going to focus on the LLC, or the limited liability company. So an LLC combines favorable aspects from a corporation and a partnership. So for example, from corporations, LLCs take the limited liability component. And then from partnerships, LLCs provide the pass-through taxation option, which we'll discuss in a little more detail later in this presentation. So limited liability means that your personal assets are shielded from any liability that the company may incur. So that includes business debts and potentially damages that are awarded as a result of litigation. So in 2020, approximately 250,000 entities were formed in the state of Delaware. Of those 250,000 entities, approximately 180,000, or 72%, were LLCs. So it just shows that LLCs are a very popular entity choice. LLCs are very flexible, which is one reason why we think you should consider an LLC when forming your entity. And as we go through this presentation, we'll explain why LLCs are flexible. So steps to form your LLC include first filing articles of organization or formation with the state that you choose as your jurisdiction for your company. And in addition to filing the state paperwork, you will also create an operating agreement. And we'll go into this in a little more detail again later in this presentation. But an operating agreement is essentially a document that governs the relationship between the members and outlines the governance structure for your company.
Okay, so now we are ready to get into the real meat of the presentation, which are these 10 things to consider when forming an LLC. So our first consideration is that limited liability does not mean no liability. When people really hear the term limited liability company, they think that they limit.
I'll be back.
Sorry, if you guys wouldn't mind muting, that would be great. Anyway, so when people hear the term limited liability company, they immediately think that they're limiting their own liability. And that really is a huge selling point for LLCs because this is true to an extent. A member is not personally liable for the debts, obligations, or other liabilities of the LLC, whether arising from, tort, from contract, etc. But a member is personally liable if that member engages in fraud, commits negligence, breaches a professional duty, or guarantees payment or liability in a contract. So we kind of wanted to illustrate these kind of 4 scenarios where you may be held personally liable for your own actions as a member of an LLC. So regarding fraud, John, a member, engages in fraud by making a business dealing on behalf of Bankers Unite LLC, while knowing the LLC couldn't pay the invoice. John may be personally liable for those damages. Here, because John specifically himself engaged in fraud, John would be liable for fraud, personally liable for fraud. And just as an FYI, all of these examples are completely made up by us. So if there really is a Bankers Unite LLC, please note we are not talking about any member who has not paid his invoice through that LLC. Moving on to negligence, Linda is a member of Construction for Less LLC. She agreed to construct a water feature on Lou's lawn. She implicitly promised that the work would be free from defects and performed in a workmanlike manner. However, she used low-cost materials and didn't construct the feature appropriately, and it flooded Lou's lawn. Therefore, Linda may be personally liable for those damages. Here, Linda personally liable because she is the one who committed the negligent act. So we will discuss in greater detail this idea of fiduciary duty later in the presentation, but for now, just generally, a fiduciary is someone who owes a duty to act in the best interest of another. So generally, members of an LLC have a fiduciary duty to act in the best interest of the LLC, the company itself, and to the other members of the LLC. So here, Sarah is a member of I Love Muffins LLC, and on behalf of that LLC, she chooses her own side business as a flower supplier, even though her prices are significantly higher than a competitor who has the same quality flower and who wanted the contract. She might be personally liable both to the LLC and to the other members of the LLC for breaching the duty of loyalty. So here she is personally liable because she's the one who breached the fiduciary duty. Finally, for contractor guaranteeing payment, the paper suppliers for Cards R Us LLC make each of the members of the LLC sign an agreement that if the LLC cannot pay the supplier based on the contract, all of the members may be personally liable for payment to the supplier. Here, all the members are personally liable because they each individually signed a contract guaranteeing this payment. And so really, as you can see from all these examples, limited liability, although sounds wonderful, is not absolute.
So an important thing to consider when forming your LLC is that LLCs are formed under state statute. That means that each state has rules prescribing how LLCs will form and operate in that state. By way of formation requirements, sometimes those differ in that only some states allow LLCs to have just one member, and each state has different statutory default rules. If we could go to the next slide on this one. Thank you. So how you decide to form your LLC will likely have implications for the future operation. Each state has statutory default rules, so they have a statute that outlines how your LLC will run if you don't choose to specify in your operating agreement. For example, if you didn't specify management structure, your state's LLC laws would have default rules that would fill in those gaps. A big question that we get at the clinic is, where should you form your LLC? Usually we would say that you would want to register where your LLC does most of its business. To do business in a different state than where you formed, you'd have to register as a foreign LLC in that state, which would require you to file and pay a filing fee. And then from then on, you would have to pay taxes there and comply with the state and local laws in that additional state. What it means that those words that I'm using, doing business, what it means to do business varies in state statute to state statute. So it's really important that if you are trying to form a Massachusetts LLC, for example, that you find access to a lawyer who really knows that state's laws so they can advise you on formation and ongoing requirements. We wanted to illustrate some differences between two states that the clinic forms LLCs in, Massachusetts and Delaware. As you can see from the chart, there is a difference in cost of forming. While it shouldn't be your determining factor how much it costs, we do see it as a real concern here in the clinic among startups and students just trying to make their businesses. So we do recognize that that is a concern. You can also see that there are different procedural hurdles in each state. So some clients are concerned about disclosing their names on filing documents. As you can see in Delaware, it's not required that members disclose their names. So that can be a factor in consideration. Also in Massachusetts, you have to file an annual report every year, as it is an annual report, but that's not required in Delaware. So it's not that difficult to file an annual report, but it is something that you'd have to do yearly and you'd have to be aware of it. Finally, on this slide, I'd like to highlight the difference regarding fiduciary duties. As mentioned earlier, we'll talk about fiduciary duties in detail later on, but it is notable that in Delaware, you can eliminate this obligation, and that is a really attractive option to some of our clients, and it is how they're swayed to form in Delaware.
Now we're going to look at some of the differences between the LLC operating agreement compared to corporate documents. So corporate documents include the charter, which is filed with the Secretary of State, bylaws, which outline the governing structure, shareholder agreements, which explain how shares will be allocated, perhaps a vesting structure, as well as a stock purchase agreement. So on the LLC front, you file articles of organization, which are similar to filing a corporate charter, but the governance structure is managed by the operating agreement. So this outlines the relationship between members, and on the next slide, we will go into a little more detail. So as we mentioned, LLCs are very flexible. And what this means is that because they're creatures of contract, you can really tailor all of the elements of your LLC agreement to fit your need. But this is also, like, as a caveat, state statutes might come into play, dictating which provisions can and can't be tailored and to what extent. But generally, the operating agreement will outline the definition of a member, who can become a member, transferability of a membership interest, which we'll discuss a little bit later. It can also outline the management structure, which will also be discussed in a little more detail in a few slides, as well as distributions. So if the LLC makes a profit, how is that distributed amongst the members? Is it reinvested? Is it split based on a ownership percentage? The operating agreement will outline all of this for ease down the road. So as I mentioned, LLC statutes provide default rules and outline specific structures for your entity. So most states do allow you to modify the default rules. So for example, Delaware allows very flexible freedom of contract. One thing that we do want to note is that most states do not require that the operating agreement be in writing. But we would like to emphasize that you should have an operating agreement in writing, just because it'll outline the expectations between the members and, again, prevent disagreements or challenges down the road.
The fourth thing you'd want to think about is management structure. LLCs are really nice because they give you a lot of flexibility and control over management structure, more so than corporations. You get to decide how formal or informal you'd like your management structure to be. LLCs can be managed by members or they can be managed by a designated manager. Owners of an LLC are called members, so that's what we mean when we say member managed. In a member managed LLC, each member would have the authority, excuse me, to bind the LLC in making decisions. Most states don't restrict ownership. So members could be individuals, corporations, other LLCs. And most states also allow single member LLCs where there's just one member. For manager managed LLCs, one or more individuals would be selected as an LLC manager, and that person or people would have the authority to make operational decisions for the LLC. It could be a member, or it could be someone hired outside the LLC. If perhaps the members think that there's someone who has really good managerial experience and would be a good manager, you could hire outside for that. The default rule would be member managed in most states, but again, you could specify in your operating agreement if you wanted your LLC to be different than the default, either member managed or manager managed. How you choose your management structure depends on a few different factors. So if your business is small and you have few members and they want to have an active role in operational decisions, you might decide to be managed by members. If your business is really complex and there's a lot of members, or they don't want to take an active role, or maybe they don't have the expertise to take an active managerial role, then you might look to have a manager managed LLC. It's really specific to the facts of your business.
Our fifth consideration are ownership considerations, and they really come in two forms, which are equity allocation and voting allocation. So we'll begin with equity allocation. So an LLC interest is a member's share of the LLC's profits and losses and their right to receive distributions of the LLC's assets. And typically this is determined by the amount of cash investment by each of the members into the LLC. But as we've said, the operating agreement really can dictate anything the members want, any type of equity structure that they really want to have. One thing to note is that LLCs do not have shares. So if members want a more comprehensible way of determining their own ownership share or understanding it better, then they can use this fictional structure of units. And basically what this means is, for example, as opposed to owning 60% out of 100% of an LLC, you would own 60 units out of 100 units of the LLC. And although LLCs don't have to structure with units, they can structure as percentages. At the Startup Law Clinic, we tend to recommend that you use units as opposed to percentages, because as you add members to your LLC, your percentage of ownership goes down. And this can really cause a lot of conflict and disagreements between members. Moving on to voting allocation, it's pretty similar in how it's allocated. They're typically allocated in proportion to those cash contributions made, so the amount of cash invested by each of the members. But again, the operating agreement really does dictate all. And so if they want different voting rights than what their cash investment is, they're welcome to do that in their operating agreement. A lot of the times this can also be dictated about whether the LLC is managed by members or managers. So for example, when an LLC is managed by managers, they typically can make decisions in the ordinary course of business without members having to vote on those decisions. But regardless, generally members can vote on amending the operating agreement, electing or removing managers, admitting new members to the LLC, calling for a merger or dissolution. But once again, and I don't mean to harp on this too much, but it's important to note again that the operating agreement really does control all of this. So although members typically vote on these provisions, they don't have to. The operating agreement can dictate whatever it would like. And each of these provisions could have a different voting structure, all based on that operating agreement. Voting thresholds include usually either unanimous, which would mean that all of the members have to be in agreement, majority or a simple majority, which is greater than 50%, or supermajority, which is a percentage that's actually just made up by the members of the LLC in their operating agreement. Of course, there are state defaults, but again, you can do what's best for you in that operating agreement. But just as an example, in Delaware, when it's a member managed LLC, the default is a simple majority, or again, 50% or greater. And manager managed LLCs don't have a default at all. So if you were a manager managed LLC, and you were in Delaware, there's no default. And so you would want to make sure that you specify in your operating agreement your voting threshold. Just to kind of reiterate this supermajority example, because it is kind of a weird thing to understand, we came up with the example of a 2-member LLC with a 60-40 split. So one member owns 60% of the LLC, one owns 40% of the LLC, and they have designated their voting to what their ownership was. So they decide that to define supermajority as 66.67%, or 2/3 of the vote. And so basically what this would mean for them in reality is that to make any decision, they would need a unanimous vote because that 60% voter doesn't have enough voting power to pass a 66.67% threshold. So it may be in the best interest of that 60% owner to change the definition of supermajority to, let's say, 59%. That way, not every decision has to be unanimous.
Rebecca, we have a question in the chat about voting. Can you have voting units and non-voting units, or would you specify that in the operating agreement?
Again, you can really specify what you want in the operating agreement. So absolutely, you can have voting and non-voting units, like a corporation usually has with shares. That's absolutely allowed, and you would just want to specify that very specifically in your operating agreement as to not cause any confusion down the line. Kind of harping again on that operating agreement power, we wanted to give one more example of how the operating agreement can kind of create whatever you want. So a lot of people will often ask if they can have minority members have veto power, even if the majority members want to make, can make more decisions based on their ownership interest. And so a lot of LLCs will put into their operating agreement this power for minority members to veto certain decisions, like leaving your original line of business, etc. We also want to note that you should really be careful of silence in voting allocation. So for example, state defaults and operating agreements can both be silent. And so if a state default is silent, then and the operating agreement is also silent, then no one in your LLC will know what to do for voting. So the example we give is in Delaware. For let's say that you guys are members of an LLC and you guys just really dislike one of the members now. You don't think he's a good guy and you want to expel him from your LLC. In Delaware, there's no state default for expelling a member. So let's say you have a Delaware LLC in this scenario, and you did not include in your operating agreement how you would vote to expel a member. Delaware does not have a default for that. Your operating agreement is silent, and so there's going to be a lot of confusion and conflict between the members about how to best vote on this. So we just want to note to really be careful of silence in your operating agreement. Finally, another note we really want to have is that it is definitely worth your time and money at the beginning of this process of forming an LLC to have extensive talks with your co-founders and your attorney about the best way to allocate voting and equity and all these other ownership considerations so that you can prevent disputes down the line. You should expect that your lawyer will walk you through all these considerations as you go. So make sure all these conversations are being had early on, even if you're feeling that it's taking a lot longer than you initially hoped it would. It's really important to solidify these things, even if they seem simple, because a lot of the times these are the main conflicts that will occur down the line for LLC members.
Now we'll discuss the infamous fiduciary duties that have been mentioned a few times previously. So a fiduciary relates to or involves a relationship of confidence or trust. So in a fiduciary relationship, one party is expected to act for the benefit of the other party with respect to that specific relationship. So for example, the board of directors of a corporation has a fiduciary duty to the shareholders to act in the best interest of the corporation. Employees have a duty to act in the best interest of the employer within the scope of their employment. A doctor has a duty to provide the best care for their patients. And just as a general example, an agent, anyone can take on a task for another party, the principal, and within that relationship, they have to act based on the duties that the principal has asked them to complete. So fiduciary duties matter in the context of LLCs because they outline the duties that a member owes to other members or that they owe to the company. So the duty of loyalty essentially means that members or managers, depending on how you structure your LLC, these duties may be modified slightly of who owes duties to whom, but you have a duty to act without personal economic conflict. So you can't steal a company opportunity if something is presented. You can't take it for your own benefit, and you can't act in your own self-interest. So going back to our I Love Muffins LLC example, Sarah breached her fiduciary duty of loyalty to the LLC because she chose her own flour company as the supplier for the bakery, even though competitors had similar quality flour, perhaps at a better price. There's also the fiduciary duty of care. So members or managers have a duty to act in a reasonable manner that would be expected of somebody in their position. So they have to be informed and knowledgeable about the operations and the business that the company is engaging in. And they have to believe that their actions are taken in the best interest of the company. Freedom of contract. So as we've mentioned multiple times throughout this presentation, LLCs are extremely flexible. And what this means in the context of fiduciary duties is that in some jurisdictions, depending on statutes, you can modify, eliminate, or expand the fiduciary duties based on what you think is best for your company. This is something that you should discuss with your lawyer just to make sure that you're taking steps that are in your best interest and not sidestepping anything or other important considerations.
Catherine, we had another question in the chat, kind of on the topic of freedom of contract. As the LLC evolves, what is the process to edit or update the operating agreement if you desire to make changes?
So typically in your initial operating agreement, you'll have a provision that outlines the process for amendments, and the voting structure for amending can vary from provision to provision. So perhaps changing the management structure would require a unanimous vote. Outlining fiduciary duties could require a supermajority vote to amend it. So again, the operating agreement governs everything. So definitely make sure you have an amendment provision in that agreement.
All right, our seventh consideration is transferability. So unlike corporate stock, interests and related management rights can't be easily transferred. So this pick your partner rule means that the transfer of a member or partner's ownership interests are restricted by statute, but those restrictions can be tightened or loosened by the operating agreement. So typically when a member assigns her interest to another, the assignee receives those economic rights like the share in profits or losses, distributions, but depending on the operating agreement, the assignee may or may not also receive other rights like voting and management rights. So an example we like to give is Delaware. So in Delaware, the state default is that an assignee cannot participate in the management of an LLC business except as provided in the operating agreement. So unless the operating agreement provides that your transferee can participate in management rights, unless it does say that you can participate, then you can't based on the state default. So if your operating agreement is silent on any of these things and you'll have to rely on the state default, there's nothing you can do. So it's best to include all of these kinds of provisions in your operating agreement.
Okay, the eighth thing that you would want to be considering is taxes. Taxation is going to be based on the number of members that you have and the tax elections that the LLC makes. If you have a single member LLC, the IRS will treat you as what they call a disregarded entity, and you'll just be taxed like a sole proprietor. But for multi-member LLCs, you can be taxed as a pass-through entity or as a corporation. For pass-through, business income would flow through to the members, and then each member would pay taxes on their share of the business's income at their personal tax rate. And so the entity would not be paying federal income tax. Alternatively, the members in rare circumstances might choose to be taxed as a C corporation or an S corporation. You would quite literally check a box on a tax form to say you wanted to be taxed as a C corp or an S corp. For pass-through, the business income would flow through to the members, and you would be taxed as a member on that portion, on your portion of that income, whether or not the LLC actually distributed cash to the owners. So for an example, I know it can get complicated. So if Rebecca, Catherine, and I were equal members in an LLC and the LLC made $90,000 last year, then each of us would be responsible for paying taxes on our $30,000 share of the LLC's income. If the LLC decided not to pay out that $30,000, but instead invest the whole $90,000 into the LLC, we would still be responsible for paying taxes on our $30,000 share, even though no cash was paid out to us. I know that that can be problematic, which is why it's important to know that there are tax protections that you can put in your operating agreement. You could make a provision that says the LLC will pay out sufficient funds to cover a member's share of the tax. Finally, on this slide, pass-through losses can be used as personal losses if you itemize instead of take the standard deduction. More deeper into the tax implications of that are beyond today's presentation, but I do say it to highlight that these tax considerations are really fact-based. They're based on your costs and your income. So it might be important to not only consult a lawyer, but to consult an accountant as well.
Steph, we got a question in the chat asking if you can speak more to the situation of electing C Corp or S Corp tax status.
Sure. So when you usually an LLC would choose pass-through taxation, but in rare circumstances, you might choose to be taxed as a C Corp or an S Corp. To do so, you would have to face eligibility requirements. For example, to be a C Corp, to be an S Corp, for example, you would have to fit certain requirements such as having a limited number of members, having only one class of stock. There might be membership restrictions. So to fit that different tax designation, you would have to check a few other boxes allowing you to do that.
So now that your LLC has been up and running for a period of time, what happens when it's time to reconsider the LLC structure? The ninth consideration that we want to discuss is dissociation and dissolution. The dissociation essentially means that a member has left the LLC. So dissociation might affect the LLC's governance structure, distributions, who has authority to bind the LLC with a third party. So again, all things that you want to consider as you're structuring your LLC. The dissociated member may continue to have certain rights and obligations after they've dissociated. So for example, if they're no longer a member, they may still have their economic rights within the LLC, so they may still be entitled to receive their share of distributions. Additionally, depending on state statute, some fiduciary duties may remain in place after they've left the company. So the operating agreement might list events that lead to a member's dissociation. For example, if a member files for personal bankruptcy, that might be a reason that they are no longer associated with your company. Whether or not statutes list default reasons or events for dissociation will vary from jurisdiction to jurisdiction or from state to state. So again, as we've mentioned, it's important to work with a lawyer that is familiar with the state laws in the state where you want to form your entity so that you understand all of these default rules. And one important thing to note is that if a member dissociates from the company, that doesn't mean that the LLC is dissolved. The LLC can continue. So in certain circumstances, an LLC might dissolve and wind up its business. So for example, in the operating agreement, you might outline that the consent of all the members is a reason to dissolve the company. They have decided amongst themselves that they no longer wish to continue. Another reason might be that they've sold all or substantially all of the company's assets, at which point it doesn't make sense to continue on with the venture. There might be an event that makes it unlawful to continue operating the LLC. Perhaps one of the members has committed fraud and it doesn't make sense to continue working together. Another reason might be that there's judicial dissolution, which means that one of the members has gone to the courts and asked the court to file or to determine that the company should not continue. The company is dissolved as of the day that that event occurs, but that doesn't mean that the company ceases to operate at that point. They're still required to wind up the business. Winding up, might involve settling the debts and other obligations that are left for the company, distributing the assets in accordance with the operating agreement. So this might mean liquidating the entity. It might also mean that the members are given distributed part of the assets based on their shares. Always outlined in the operating agreement. So you'll want to make sure to think through all of these processes. In addition to winding up the business, you'll also want to make sure that the certificate of organization or formation is canceled once everything has come to an end. So liquidation of the LLC, you can outline whether it's the members or a third party that's appointed and chosen by the members that has the ability and the authority to liquidate the company's assets. Death of a member. So in the unfortunate circumstance that one of the members passes away, the LLC does not cease to exist. The LLC can continue. The deceased member's interests may transfer to their beneficiary if that's permitted under the operating agreement.
To address a tax question in the chat, can you change the tax election at later times? You can. You would have to file a specific form, I believe it's form 8832 with the IRS, but you would have to be an eligible entity at that time. So for my example about S Corps, you would have to, your LLC would have to have that limitation on the number of members. I believe it's less than 99 members. You'd have to have fit the boxes for eligibility. So have the number of members that you're required to have, not have more than one class of stock. So you have to be eligible at that time, and then you file the forms, and you'd also file a consent of the LLC, and you could change that election. So to be taxed as a C Corp or an S Corp, you're looking for that entity level taxation, that double taxation, which is how it differs from pass-through. But you could reevaluate at a later time and just communicate with the IRS about what you're doing and what your eligibility is. Just reading in another question about the taxation, C and S Corps don't have pass-through tax treatment. No, they don't. So they have double taxation. You're taxed at the entity level and at the individual level. Pass-through is when the entity level is not taxed. The income would actually pass through. That's why they call it pass-through. So it flows right through from when the company earns the money, it goes right to the members, and then it's taxed to each member at their personal tax rate. So it's a little bit different of there's only one line of tax instead of double taxation. For more taxation questions, it can get pretty into the weeds, but we'd be happy to answer them at the end, because we are at our 10th consideration for when forming an LLC. So at some point in time, you might think that you'd like to convert your LLC to a corporation, or your corporation you'd like to convert to an LLC. Both are possible and both have different implications. It's not uncommon for founders to start their company as an LLC and then for more flexibility, and then down the line decide to transition to a corporation. It can be in response to a lot of different factors, but a main driving factor is that investors are likely unwilling to invest in a corporation, to invest in an LLC. So they'd like that the LLC transition to a corporation before they make their investment. Converting to an LLC to a corporation can take time, but the process is relatively straightforward. You file a conversion document and you draft your corporate documents as well. It usually does not trigger immediate tax liability in comparison to going the other way. From corporation to LLC is a bit more difficult. Basically, you would be liquidating the corporation and incurring tax implications at that time. Often we see that the tax consequences will outweigh any benefit of doing so. As I said, when you think about converting to a corporation or just starting as a corporation, you might be concerned about attracting investors. So typically venture capital firms, they don't like investing in LLCs. They want to avoid pass-through taxation. The reason for that is that they often have tax-exempt investors. Maybe they have foundations or charities as their investors who don't want business income to pass through to them. Another reason is that LLCs are a newer entity type than corporations. So VC firms feel more comfortable working with corporations where there's a large body of court decisions to guide any possible disputes that come up. So they are a little bit more comfortable with what they know, which is corporations. But all that is to not deter you from becoming an LLC, because there is that conversion option. If you start out as an LLC because it makes sense for you right now, and deciding to transition to a corporation later on when you're looking to attract investors.
Okay, so in conclusion, LLCs are a very popular entity choice, mostly because of the flexibility that they provide in comparison to corporations, while also still providing that limited liability, with the caveat, of course, being that the limited liability does not mean no personal liability. If you are considering setting up an LLC, you should still definitely talk to a lawyer to see if this entity choice is best for you in your specific circumstances. But if you want to talk to us and you qualify for our services, you should absolutely fill out an intake form on our website, which is on the screen, again, or you can just Google BU Law Startup Clinic, and we would love the opportunity to work with you. So now we are going to open up the floor to some Q&A and answer any unanswered questions in the chat.
Rebecca, could we flip back to the why investors don't like LLC slide, please? We have another question in the chat. What are the main differences between LLCs and corporations apart from pass-through taxation? So this is one of the things that Catherine touched on. If I wanted to pass it over to Catherine, talking about the differences in formation documents is a really big area of difference between them.
Yeah. So just at a baseline, corporations do have more documents that have to be completed as part of the formation process. So it's a little more complex and it just takes a little more time. The bylaws outline the governance structure, so similar to the operating agreement. The shareholder agreements outline the vesting structure, how shares will be allocated amongst the founders, and then the restricted stock purchase agreement will go into a little more depth on the transferability of those shares. And all of that is encompassed in the LLC operating agreement.
We have another question. If two co-founders are considering forming an LLC, how do they settle disagreements over the operating agreement? I think a line that we said a lot, because it is so true, is that it's really important to consult a lawyer about it. If you're fighting before you form, or maybe not fighting, but disagreeing before you form, it can be an indication that there might be disagreements down the road and that you really need to specify all the areas that you can in your operating agreement for what to do if things go wrong or what to do in different sorts of situations. So, speaking with a lawyer about what your aims are, what your goals are, and different levels of protection, different voting powers, and then also management structure would be some areas to focus on with a lawyer, and they could best advise you what the default rules are in your state, or how to specify your own rules for operation.
Just to speak to the immigration question that was posted at the beginning of the presentation. So because we service students at BU and MIT, we do often encounter students who are not United States citizens. However, we are not immigration attorneys. That's not our specialty. And so what we would recommend, if you guys are concerned about any immigration issues, is to fill out that intake form on our website. And if it makes sense, then we can refer you out to an immigration attorney, or answer any basic questions that we may know specifically about like F1 visas versus student visas and what those implications might be when forming a company at the very beginning. But again, because that's not our specialty, we don't like to give concrete legal advice on it, and we would rather refer you out to an immigration attorney that specializes in this type of work. I'm trying to see if there are any other questions in the chat, but also please feel free to unmute and ask us any questions that we might be able to answer for you.
Just to say thank you. This was extremely useful for me. Great intro. I have an appointment with you guys already, so looking forward. Thanks so much.
Great. One other thing I also wanted to mention about the differences between LLCs and corporations, other than just their taxation and their documentation, is just that general idea of flexibility in LLCs is not necessarily as strong in corporations because there's so many more laws about keeping corporations so structured that it provides for many fewer, much less flexibility when forming an LLC versus a corporation. So if you're looking to kind of create your own rules in this and do what's best for you, an LLC might be a better designation for you than a corporation.
Yeah, thanks a lot. This was quite helpful.
Maybe you can discuss a little bit about compensation on a single member LLC. How does that work? Because the way I see it is, if I'm funding my own company at the very beginning, I'll have to put money from my bank account into the company's bank account, pay myself, pay the government, the IRS, and retain keep the rest. I don't know if you have any.
Yeah, so a single member LLC is essentially taxed as a sole proprietorship. So the LLC is disregarded by the IRS. So you would be able to use your losses on your personal income tax return, even if you were paying yourself from the LLC.
Perfect. But that payment, I assume I would have to pay. I'm not so familiar with the US benefits payment, but I'm guessing I have to pay Social Security or things like that are standard, right?
Yeah, you might incur some self-employment tax, but that's something that can be explained in a little more detail in your one-on-one, and also like an accountant might be able to answer those questions more specifically.
Perfect. Do you have also referrals to accountants by any chance at the clinic? Do you do that? I know I'm asking a lot, but just in case.
No, it's no problem. I actually don't know if we do. We could definitely reach out to our professors who are the attorneys and see if they have any connections. But off the top of our head, I don't know if we actually do refer out to accountants.
That's fine. I can jump in on that. We get that request a lot, and frankly, for a small business, you don't necessarily need, an accountant from like one of the big 4 accounting firms. You can go to a service like H&R Block or TurboTax, and they have specific accounting services for small businesses. But if for some reason you did need someone who's a professional and costs a lot of money, we could try to set up that situation. But you're probably fine just going to something that you can find online.
Thanks, Sam. No, the reason I ask is because I'm a foreigner here, so. Yeah, I don't think sometimes, we have extra requirements that we need to comply with, and I want to make sure. I've heard, for example, that when you pay yourself, you have to file an additional form, and if you don't do that, the standard penalty fee is $25,000 just because you didn't file the form. So I want to avoid things like that, but that's immigration specific, I guess.
Right. So yeah, definitely good to have someone who's a professional who can help you in that.
Thank you. Thanks, Sam. All right, I'm good. Thanks so much.
Yeah, absolutely. And we'll stay on for another, couple of minutes. So if anyone lingers and wants to ask any questions, feel free. Otherwise, thank you guys so much for coming. And these slides, and I believe the recording of the session will both be posted on the Startup Law Clinic's website in the near future. So you guys can refer back as needed.
Thank you so much, everyone.